We're live.
There we are. All right. Good evening, everybody. Welcome to the Town of Mount Pleasant Zoning Board meeting for February 8th, 2024. My name is Nicholas DiCicco. I am a zoning board member sitting in for the chairman, Ron Presner, tonight, our esteemed chairman, who is not here because of personal reasons. As we only have 4 members of the board tonight, you are entitled to an adjournment if you so desire. However, you can make that call later when it's your case is being called. Let me introduce the other members tonight. Sitting with us to my right is Mr. Scott Travella. Sitting to my left is Kathy Niclario from the Town Building Department. To her left is Herb Dorr, zoning board member, and to his left is zoning board member George Lapatsos.
And Joe Outfront.
Sorry?
And Joe Outfront.
Oh, and our esteemed building inspector Joe Briganti is sitting at the front table. Thank you. The procedure tonight is as follows. Once your case is called, you will be sworn in. I will read into the record the application. We will ask the applicant to make a presentation. The board will ask the applicant questions. We will then take public comment. The applicant or the representative for the applicant will be asked to reserve any rebuttals to public comment until the end, where he will be given, or she will be given, opportunity to respond to any of the public comments. Once the public comment period is over, the board may decide to make some comments amongst ourselves and have an immediate vote if the case calls for it. The other option is the court may decide to wait until the end of the meeting and move into a business session to discuss the case in more detail and then have a vote at the end of the night. The other option as well is the case may be adjourned and or the matter may be closed for decision only. I would like to make the public aware of the typical considerations that we apply to each and every case that comes before us. Most cases, as tonight, are area variances. In every case where there's an area variance in question, the board views the case through the following 5 factors as determined by Town Law 267B. The Zoning Board of Appeals shall take into consideration the benefit to the applicant if the variance is granted as weighed against the detriment to the health, safety, and welfare of the neighborhood or community by such grant. In making such determination, the board shall also consider 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the variance. 2, whether the benefits sought by the applicant be achieved by some method feasible for the applicant to pursue, other than an area variance. 3, whether the requested area variance is substantial. 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood. And 5, whether the alleged difficulty was in fact self-created. This last factor, while is considered and relevant, it shall not necessarily preclude the granting of an area variance. I read that to you now so we don't have to reread that for every single case, but for the public's awareness that those are the considerations that we have in each matter before us tonight. That being said, I believe we are ready to move on to our first case, which is case number Z23-59. The matter of Claire Pearson, owner of property located on Bedford Road, proposed as 747 Bedford Road, Sleepy Hollow, New York. Section 111.5-1-2. The application is for the proposed 2-lot subdivision, which is currently seeking planning board approval on a legal parcel in the R40 zone. The following variances are requested. The variance requested is a variance from the required street frontage on Bedford Road. The required amount is 25 feet. The current existing amount is 0, and the proposed amount is 0, thus requesting a 100% variance of 25 feet. Would the applicant and or their representative please come up? Thank you. Could you just state your name?
Sure. Good evening, Acting Chairman, members of the board. My name is Taylor Palmer. I'm with the law firm of Cuddy & Fader on behalf of the applicant. Tonight I am joined by Stephen Spina from JMC, our project engineer. I'm also joined by Joan Ricelis and Till Globig, who are part of the project team, and the applicants are joining us this evening here in the audience.
And Mr. Palmer,
yes.
do you swear to tell the truth, the whole truth, and everything stated tonight will be accurate to the best of your knowledge?
Yes.
Thank you, sir.
Thank you. As the acting chairman mentioned, we are before your board this evening in connection with a public hearing for a New York State Town Law 280A variance, and we'll get into those details in just a minute regarding the lack of street frontage for this particular property on the premises. And if I may, just for the benefit of the board and the members of the public that are joining us this evening, I'll give you a brief history of the subject parcel and the reason why we're before you tonight. Several years ago, back in 2018, the applicants worked with New York State, who are the abutting and large property owners in proximity to the property, and did a land swap agreement with the state regarding this parcel. They were provided, the applicants previously had certain lands that were abutting Bedford Road in this location, and then ultimately were swapped, which you'll see on the board and included in our package, for the parcel that's before you today. You're all likely very familiar with this location. It is just north of the entrance to Stone Barns, and it's the open spaces that are on both sides of the street. So the parcel that's located in red there on the screen was the original, the applicant's property that they then swapped with the green parcel that's there located behind their existing residence. So in exchange for that, keeping that pastoral frontage along Bedford Road, just that, and locating their residence in the green parcel, they did do this land swap, which is accessed off of a private shared driveway off of Bedford Road. The applicants then engaged the town to determine the required process that was associated with that formally recognized land swap, and they began planning for construction of their new residence on this swapped lot. At that time, the town determined that a minor subdivision was required to legally affect those two lots. So last year, the applicants applied to the town planning board and then worked with town staff to coordinate that subdivision application. So toward the ends of last year, the planning board was in the review process, and the applicants were informed by the building department that a variance was necessary for frontage on a public road. Again, the property being accessed off of a existing private driveway that's also utilized by a property to the east, which again, my colleague will review with you in just a minute. Following that termination, the applicant did submit to this board for that requested variance and met with the building department to review the frontage and the application materials that would put forth. What's interesting about this application is typically a 280A variance, such as the instant application, would come to you at the time of a building permit. That's the sort of driver of this. Here, a building permit had been issued and the home is actually fully constructed and on the property and accessed by the existing driveway. So this is sort of a learned after the fact. Just by a little additional background, and then I'll put Stephen on just for the subdivision plan and showing the access. The property is currently accessed from Bedford Road. There are two access easements over the existing paved driveway. So there's a section that comes from Bedford Road into the site, and then there's a spur that goes over state parkland. Both of those are access easements existing to the existing. The macadam driveway, or the shared driveway, is a 50-foot right-of-way, and the driveway itself into the site is a 20-foot right-of-way, but there's also a driveway in that location. So while we understand this issue was discussed with town council and with the planner previously, this determination was rendered, and as noted by the acting chairman, zoning code section 218(9)(b)(6) mandates that a permit may not be issued for a building unless that lot has 25 foot of street frontage, leading us before you this evening. So with that, there is a specific provision on top of the 5 factors that you all discussed tonight that is before you, and that is directly from New York Town Law 280A section 8 sub 3, which provides that a variance may be granted upon showing that the access to the property is sufficient to allow for the ingress of fire trucks, ambulance, police cars, and emergency vehicles. For the benefit of making up words, I call that firematic access. So that is what effectively we're putting forth. And we did include in our submission diagrams of the largest apparatus for the town entering into the site and being able to exit. So just for the board's reference, the premises access off of a 15-foot, so that the requirement in the town law is that there be a minimum of 15 feet. At no point is the driveway less than that. In fact, we're wider than that in all regards. So ultimately, and as we submitted in our December 18th letter, we do support that the granting of this requested relief will not result in any undesirable changes in the neighborhood. And given that access already provides to an existing residence, again, east of the site, serving this premises, there's going to be really no change to any of those conditions through this application. So with that, I'll just briefly turn to my colleague from JMC just to walk you through the site plan itself, and then certainly pleased to address any questions from the board or the public.
Thank you.
Thank you. Good evening, everyone. Steve Spina from JMC. We're the site engineer on the project, and I'm going to take you through the site plan up here.
Sworn.
Yes, sorry. Mr.
sorry.
Spina, do you affirm or solemnly swear that you'll tell the truth and state accurately all comments tonight to the best of your ability?
Yes,
Thank you.
you're welcome. Okay, I'm just going to put up the site plan here on the console as well. Okay, so what we're proposing here off the private driveway, roadway here, is another private driveway all the way up to the home, shown in gray on the plan. The home is the yellow structure, and it is setback within all the required setback distances. We meet all forms of the code in terms of the property itself, in terms of setbacks and trying to avoid steep slopes. We're proposing drainage to mitigate the impervious surfaces that were created, and there's a wetland here with a buffer, town wetland, and we respected that in terms of impervious surfaces, disturbance. We do have a little bit of grading that was done temporarily in the buffer for a proposed septic area, and an expansion area that was done in accordance with the Westchester County Health Department. Most notably, I guess, in terms of the access, we come up here, and in order to get, because of the length of the driveway, we have a little pull-off area with 2 parking spaces additional in order to meet the code for the driveway. And I guess lastly, there's a little access road that was made in order to get to the septic area to maintain it in the future. So that's pretty much the highlight of the plan itself. I don't know if anybody has any questions, or should I continue on?
Well, when you're done.
Okay, so, and then we did, as Taylor alluded to, we did review the fire truck analysis with the board, with the planning board, and we show that the fire truck can get up to the home and then get back out and turn and go down the driveway. We typically don't do that for single-family homes, but we were asked to look at it. You know, most single-family homes are, you know, a special case, and hopefully you can get the truck to the home, which we can here. And you know, so we kind of try to treat it like you would maybe a commercial analysis, you know, for fire access. So that's really all I have in terms of describing the site plan.
All right, so I have some questions, perhaps Mr. Palmer. I'll open up to the board as a whole, but if initially, you stated that in 2018 there was a formal land swap. Where was that recorded?
So there's deeds recorded for these parcels, and there actually are tax IDs that are associated with these parcels as well. That came about when they were working to get electric to the property as well. So there are tax IDs, and these are recorded deeds on a file with the county.
As far as the subdivision of this area in its grander scheme, which I know there's a lot of land there.
Right.
Do we have any knowledge when it was originally subdivided, that the applicant, the property right on Bedford Road and the subject property tonight, when that was actually subdivided?
If I may, Acting Chairman, are you asking when the existing lot? So if you want to, Stephen, you want to bring up the green and red plan?
Let me clarify my
Yeah.
question. I know you're seeking planning board approval now to formalize that subdivision.
Exactly.
But if you look on the county website, it's already a subdivided lot.
So the county, to your point, Acting Chairman, it absolutely is, and they've actually, I believe, been paying taxes for the specific lot it's illustrated, but because it wasn't formally done as a formal subdivision through the planning board's process, from a town perspective, it doesn't truly exist as a formalized lot. So the county's tax parcel viewer, as convenient and useful as it may be to see the old historic aerials, shouldn't be relied on for that. The town's tax map will need to be updated, and then the county's parcel viewer actually won't change, but you'll be able to click on it.
You would agree that at some point the part in the process where the town of Mount Pleasant is supposed to be advised of that subdivision, like, didn't happen necessarily?
So in this case, it's about a 200 some odd acre lot of the states, and going through the land swap process, it wasn't identified as needing, because it was a swap. They're effectively not creating, to say that they're creating a new lot. The parcel, the Pearsons owned that red parcel, so that was it. That itself was a lot. They owned it, and it existed. So not creating any new lot. They're sort of flipping the acreage from one to another. But to answer it directly, Acting Chairman, yes, it should go through the subdivision process, which as soon as that was identified, they then spent a significant amount of money and time to go through the formal process of carving this up. And again, working with the state, it wasn't identified as an issue because it was literally just flopping the lands, not creating a new lot.
So thank you. So the next area that I'd like to ask you about is the identification of the road. The macadam driveway, it's called, I believe, on the plots. It's not a identified road on a town map. Is that correct?
That's correct.
And you believe refer to it as an access easement.
So let me clarify. So right now, the macadam driveway, which is it's a right of, excuse me, I probably shouldn't use the words right of way. I mean, it is for the purpose of accessing this parcel, but it's a driveway. It's a private driveway that provides access to state property and another residence further east along that driveway. The Pearsons' existing residence, which actually fronts on Bedford Road, also accesses their home, shortly after Bedford Road. You enter the driveway, and then their property has a driveway there. This driveway will access further along this private driveway. So if I misspoke or confused the words of right-of-way, we have an easement. The Pearsons have an easement over the state's land, which is the private driveway, to their residences.
So, in other words, that is an easement.
It is an easement.
You're calling it a driveway, but you're correct in saying that road going up there is an easement.
They have an easement over an existing driveway, correct?
Is that reflected on the deed?
Yes. They have a easement within, that's recorded with the county. For both the macadam driveway and then there's a spur that comes off of that macadam driveway, still over state land, into the property. So they have two separate recorded easements into the site.
So, and just for the record, for everybody's knowledge, the town zoning board did make a site visit there last week,
Okay.
as we have on all applicants' tonight. So we have walked the property.
Great. We brought pictures in case, but that's great. One of our consultants is actually a planning board chair in another community, and I teased her. I said, if you ever really want to get a lawyer when they're at your meetings, ask them if they've been to the property.
But we've been
We were
there.
there, we drove all the way up, and we drove on what are also named paths within the state/Rockefeller property.
Yes.
Is what this all was
Yep.
initially.
Exactly, and it's state parkland surrounding it, and you're again familiar with that area. There's a lot of folks
So
that come through.
what I'm really getting at is that there's a legal distinction between a mapped road, a private road, or a private driveway and easement. I think we would agree there are distinctions there, to say the least.
Yes, if we were a town road or a private road, then we wouldn't be before you because we would have however the parcel could have been drawn up, would have frontage along that. But because it's a private driveway, even if it's at road standards, it doesn't meet the distinction in New York town law. And as a result, we need to appear before you. We provide, what we were showing you is that we have that firematic access. That's the test that comes out of, treating it like a flag lot or other, concept. Here it's,
That firematic access is
Can I ask
more.
on that one?
Sure.
While we're on that, Nick, firematic access, what truck did you have drive up there? Whose truck? You said in the larger one in the area? Which one?
I'll
is
ask
it?
Steven.
Just
Yeah,
because I
I'll-
know the mechanical fire department very well, and I know what trucks they have and what they just replaced.
you're going to have to use the mic, Stephen.
Okay, so this is the truck the truck information we got from the fire department.
From Mechanical Hills, Sleepy Hollow, which fire department?
So this is from I think it's from Elmsford, and then we confirmed that with I think it's the Archville Fire Department down the road, I believe, too.
It's actually
I don't know.
Mechanical Hills Fire Department.
Okay, maybe they.
I'm ex-chief of Thornwood and on the Mount Pleasant Chiefs Association, so that's why
Okay.
I'm saying. Elmsford is not a first responder to that house. If that homeowner called 911 and asked for a fire truck, it would not be Elmsford.
Right.
Elm Street is not even part of the town of Mount Pleasant. We have trucks bigger than that notion there. My own tower ladder in the fire department in town, which is on the mutual aid plan. So what I'm bringing out, just for the record, is it's a fire, you went by a truck, which is great. I mean, there's a lot of people that we've had build, and they put these gates and pillars up that we can't get a fire truck through. And we'd have to blast the gates through to get a fire truck to somebody's house on a homeowner's residence.
Understood.
And I understand your point about homeowner and commercial, et cetera. So, and we drove up there, and I drive a Tundra, which is not a small little vehicle, it's a pickup. So I saw what size road you put in, you have nice drainage on it, et cetera. So I'm just going for the record that that's not the appropriate truck that was used firematically. And if we had to bring a tower ladder up there, which is usually one that we bring up, or a pumper, it doesn't match either.
Understood. And just to clarify, Mr. Spina mentioned it was the Hawthorne Fire Department, not the Elmsford Department, but just for the purpose of the record as well, we put this on here to try and go above and beyond what the standard is.
I
The
totally
standard is the
understand that,
width.
but I'm just saying, if you're gonna
Understood the
use the
distinction.
appropriate stuff and do the research,
Right.
you use what's gonna respond to that area.
Understood. And
The idea being is that when people do a firematic access analysis, that's typically going to try and show that the road can be considered a private road as per other general town standards, things of that nature.
understood.
Okay. Right, is that fair?
Well, for this access plan, the standard is looking at it that it exceeds 15 feet in width, and we do. So that's the standard. We just
The curve coming in, does it get a little tight if you have to bring it up? Because you gotta remember too, most of these fire vehicles carry maybe 1,000 gallons, if not less.
Understood.
And there's no hydrant right down on the bottom, and there's no close pond to draft water off. So now we have other engines and other vehicles coming up from a weight standpoint.
Understood. And just at that point, and Acting Chairman and member, we're going through the process with the planning board. So this is, by reviewing this with you, this is by no means a done deal. We still have to appear before them in connection with the subdivision review. So to the extent that this process is still an open one, that is still being reviewed from a planning perspective as well.
Yeah, so on that, my last point of inquiry that I had written out is, can you just talk for the record about the other houses, describe in a little more detail, how many other houses are currently using that access easement on that private driveway? And if you can, talk to us about, are those other houses legalized, pre-existing, non-conforming, or what have you?
I'll have the applicant speak to it just because
Great.
she can speak to the family that's also along the road there. You'll just have to swear your name to the record.
Is that your name, ma'am?
My name is Claire Pearson.
Thank you. Do you swear to tell the truth, the whole truth, and make all statements accurately as best as you can?
Yes.
Thank you.
So, in addition to the house we live in currently, which is right off Bedford Road, right off the shared driveway, then the next one would be the new house we're hoping to move into. Then Michael Quattrone is the next house. They have twins who have they had febrile seizures, so there was ambulances going up and down the road to visit them when the kids were small. And then the fourth house is Peggy Delaney, and I don't think there's ever been any fires or anything like that up there. So we had a fire. We had so the fire trucks got into our house from Bacanico a couple of Christmases ago. So
Not including the house that's currently under construction, the subject house, there's 4 houses that use that driveway?
There's 3.
3.
Yeah.
So this would be the 4th.
This would be the fourth.
This would be the 4th.
Correct.
And are you aware, or maybe if your attorney is aware, if those houses have been legalized, or they pre-existing non-conforming uses, or what's the nature of those lots and those houses?
I'm
I can speak to that.
okay.
It would have been the same answer that Ms. Pearson, I believe, would have given, though I won't speak for her. We do not, we believe they're pre-existing non-conforming, but to the extent otherwise, they're not. There's no record. We understand that there are no other 288 variances, whether they just haven't appeared before this board or otherwise. But when we requested records of other instances, there just hadn't been, and that may just be recent advent of going through this particular process.
Thank you. Open it up. Obviously, it's always an open forum, but Mr. Travell, do you have anything specific?
Not at this time, Mr. Chairman.
Mr. Dorr?
I think you've already put that into place, but that little triangle piece that, where the current new driveway comes down, I'm gonna call that the driveway coming from the new residence, that is all state property? Is that parkland? So if I'm looking at this, you got the yellow line.
Oh, sorry, I was looking up at the
Driveway.
screen, yep. Yeah, so
Looking at
the,
this picture here. So that, it's got the open field and then a little wooded area there.
take this with me.
That triangle, correct.
Oh, yeah,
That's
Yes, this
That's
is-
part of the state land
Yes.
that's across the street?
correct. And then our access easement is right here. So that we have an easement here, that's easement 1, and then there's a second easement, and then this is just their property. So easement, easement. Both recorded.
So there was no way when they did the land swap that yellow
would have never
line could
fronted
have gone
on-
up, fronted onto that?
No. Correct.
So you're saying the driveway with exclusive access to the home, that has an easement recorded as well?
Yes, this
Okay.
residence is not part of the application,
Right.
but that's where the applicant presently lives here. This is their new,
Meaning that little driveway up there? Yeah.
yes, exactly, that comes
Okay.
right here. And then the new driveway, this is the access. So it comes in here and comes around to the house. This is an older aerial, but as you all saw, the driveway now is fully on-site. And has access easements, yes.
Mr. Hopsel?
Just in terms of the options that exist, aside from your request here for what is in effect 100% variance, without having to make use of the easement that you said is deeded, what other options are there for accessing the property that would allow for use of the front parcel, which, as you said, the applicant also owns? What options are available to make use of that conforming lot, which would obviate the need for you to come before us and ask for such a significant variance?
Understood, sure. And certainly the substantiality of a variance is only one factor, and it's certainly not determinative in an application. So the extent
But
that it's...
alternatives is a more
Oh, hun-
substantial factor, and that's really what I'm getting at. What were the alternatives that you
Right, so
considered?
the
and
other
why
alter-
did they not, prove
Understood. So
attractive?
if you've been out to the site, the topography is pretty significant. So as far as being able to access this site, put a home on it, and build a driveway to access it, you'd be impacting some pretty significant steep slopes. For example, if you tried to come through the residence here, this doesn't do a good job of representing the topography. For those who have been out to the site, you know that the house is perched up on a hill. So to answer the question directly, an easement could go over the lands for the adjoining property, creating a flag to that lot, and otherwise creating sort of a meandering second driveway, sort of impacting really the character and quality of that area. The idea is to set back, I mean, I'm presenting it as an applicant perspective, but the part of the reason why the swap is so important is because rather than building a home right in that beautiful pastoral area of the property, now this is set back from the road and maintaining sort of the quality and character of the area. If you did this, you'd create yet another connection. You'd probably have to review with DOT whether they try and merge those driveways together. There'd be a whole host of other issues that may be presented, but the primary one that would impact and would substantially increase the cost and other details would be creating a new driveway out to Bedford Road through the abutting property.
Why would it have the additional cost that you referred to?
Just for constructing a driveway through the steep slopes to get into the site. So,
But you incurred all that expense with the current driveway, no?
well, so there's the existing spur, and then they came into the site sort of to avoid the steep slopes. This was designed, the consultants that are with us this evening are consultants that help for environmental sustainability and to encourage development that sort of fits with the character and sort of builds into the landscape, these homes. So this home was designed with all of that in mind, but also because it was a direct land swap with the state to try and affect us.
So is the short answer aesthetics?
I think aesthetics, but also cost and access
See,
purposes.
but the cost thing, I'm not really accepting that, because in effect, you had two available options. You chose one and invested the money that you invested in order to make that lot accessible. If you had chosen not to require a variance and had chosen to use the front lot, which is, again, an
Right.
available option because it's shared ownership, you wouldn't have needed a variance at all.
Understood.
You would have then used the resources that you allocated towards making the current drive, the access, and basically, I don't see it would have been.
I think I can answer the
additional-
question a different way. In
Okay.
2018, when this came before the planning board, the access, the location, where it was discussed with council, was discussed with the planner, and this issue wasn't identified as being an issue that required any relief from your board. The applicant proceeded with the project, got a building permit issued, which should have triggered it again, didn't. The whole home has been built and constructed, the driveway, the drainage, all of those materials built. If we were in a hypothetical circumstance where this house and residence didn't exist, all of those improvements hadn't been done pursuant to validly issued building permits and otherwise, I think those are reasonable, but the cost to adjust and change this at this state does weigh into the considerations of the alternatives analysis, because an alternative can't be so significant so as to necessitate the applicant
You
to.
have to understand, our analysis usually doesn't take place after
I
complete construction and
I totally agree with
all
you.
full expenditure of you
You're
know,
absolutely right.
The costs associated with constructing a home.
Right, and that creates the
Normally,
uniqueness here.
the cart doesn't come before the horse.
I'm with you, and as soon as the applicant was made aware of this issue, which again had been fully vetted with the planner and with council, they immediately submitted to your board in the hopes of presenting this application and being able to proceed, because again, the firematic access is provided, and it is sufficient and more than what would be otherwise necessary. And again, I think overall, when you balance all the factors and you look at, again, where this home is in relation to where it could have been in the context of this character of the area, I think it's the better alternative.
So, I have a few more questions, and then I know we want to move on to public comments as well. Are there any other identified alternatives, even if they're not desirable alternatives, other than what's been presented as a possible flag lot or a driveway? Is there anything else that has come up or was discussed? For
There wouldn't-
adding on more property, doing something that we haven't mentioned?
It would necessitate, you'd have to discontinue parklands, so you'd have to have the state, because again, the land swap was already affected. So to the extent they had to carve from other parcels, you would have to go through a whole process of discontinuing parkland or other uses. I mean, to say that there are other alternatives, there are no other alternatives that are being considered, because again, they were issued a permit to build the residence and then built the driveway pursuant to those approvals, and now are being advised to proceed before you. So, no.
As far as the easement issue, which makes this one a little bit trickier, to be honest, because you have two easements. It's like, if you're an attorney, there's hearsay, and sometimes we use the term like double hearsay to say, we're really getting far afield sometimes from the intent here. How does the fact that, whereas if the subject property was actually fronting on the access easement, perhaps that might make the application more palatable, but now you don't only have one access easement, you have two.
So in effect,
If you could speak
Sure.
to that and how that factors into our consideration.
Understood. So the easement could be merged into one easement. It's the same grantor. It's the state granting to the applicant the ability to access the property. So it's whether I call it abbreviated New York State, NYS, or the state, it's the same grantor that provided those access easements. It just was because of the land swap, that was the adjustment that was made. There was no need for that originally when this portion of the land was part of the broader parkland piece. So when this was, land swapped, so to speak, that's what created the need to extend it. Or you'd have to have discontinued parkland. Again, wasn't identified as an issue then, and ultimately it's sort of coming into us at the end of the process here.
Right, and I apologize, I do have one more question. Perhaps your client can answer it.
No problem.
Just wondering, for how many years has there been 3 houses utilizing this access point? Approximately.
So the property, the house we live in is a Victorian farmhouse. So that was built by a farmer. So that was probably, it's 1890s. The stone house at the top, at the second one on the driveway, not counting the new building is the carriage house for the Christian Brothers Monastery. So that's been there for a couple hundred years probably. The cabin at the top of the hill was probably built in the 70s. Larry Rockefeller built that, and I don't know but I think probably the 70s would be my guess.
So since, to the best of your knowledge and recollection, since the 1970s, there's been 3 families and 3 houses utilizing this
Correct.
access point.
Correct.
Thank
Yeah.
you. Thank you. All right, if there's nothing else, we'd open up. Any other questions for the attorney?
Yeah, I just feel like it's necessary to explore, at least for the record. You mentioned there were environmental factors. Can you expound upon that? That led you to construct the driveway the way
Would you
it
like to speak
currently
to it?
exists?
Sure. Yep, I'll have Joan Marcellus, just the environmental consultant, speak to that.
Thank you.
Hi, Joan Raiselis.
Oh, sorry, yes.
And yes, I will,
Please swear
I
to tell
will,
the truth, the whole truth, and state all of your comments as accurately as possible.
yes, happy to. I was hoping to respond to your question because if you look at the way the driveway cuts down to here, if we had to move the driveway on the property, even to the other existing, you can see that this is all wooded. You saw that it was all wooded, and it's all on steep slopes. So what this does is it allows you to make the shortest driveway from this spot and utilizes an existing clear path that would eliminate the need to cut down all those trees. This is actually sort of a natural, it's not a declared wetlands, but it is a drainage area. So by allowing that to stay, you're actually allowing that absorption into the ground in a natural way. You wouldn't have to put a Coltech system in or something like that. So this whole thing is actually much shorter than trying to get down to the road on its own. So that road helps, helps to preserve a lot of the property as it is.
Yeah.
And Claire and Peter are not thinking of sort of clearing any of that property out. They're going to leave it wooded. They're going to let the ground absorb the water as it should. The wetlands are going to stay. They're not going to be touched. So I think in terms of just being a sustainable property, this is sort of, it's a completely non-polluting house. It's going to retain its heat. It's going to use an incredibly small percentage of heat compared to a house, any other houses in the area, because it's hyper-insulated. Solar, it's basically a net zero house. So the whole property is going to contribute to that, as will sort of the driveway.
Yeah. See, a lot of what you're referencing, though, again, still falls to aesthetics. And we have a lot of lots in the town, not just in the beautiful property that we're talking about here, but a lot of lots that are, in effect, what we would call landlocked. Lots that aren't buildable because they don't have road access.
Mm-hmm.
If people started buying up those lots, thinking that we could, in effect, take advantage of precedent rulings by this board to allow for variances of the 280A, we could wind up confronting this scenario under less compelling circumstances. And we have to be wary of that. We don't only have your application to concern ourselves with, and I do appreciate the beauty of the area. The lot it's gorgeous. Some, would suggest that there's a benefit to trying to maintain the maximum natural topography, and I agree with you. It is beautiful. That's not the only consideration that we have. In fact, it's really of all the considerations that we take into account, it's the least compelling to the board, not to the homeowner. The homeowner, it may be paramount, but our position is more complicated, and we do have to concern ourselves with how we treat this application vis-a-vis future applications that are going to be seeking the same type of relief, where normally 100% variance for a landlocked lot is not something, we would consider that normally a non-starter. But
I think I can
They're
give you a
gonna
lot of, I
apply-
can give you a lot of comfort here. So to the extent you mentioned the word precedent, I'm a lawyer, I do this land use stuff for a living, and I enjoy it thoroughly. If I could live on the precedent word and be able to utilize it more often, I'd love to. But what you're suggesting is that if an applicant comes before this board with a validly issued building permit with a home constructed on a hill that has this exact acreage, that's access off the Bedford Road, that utilizes 2 private existing right-of-ways, that has more than 15 feet, then I have precedent. To the extent that it's any other can change conditions.
You know land use law, we're not bound by precedent.
Understood.
Okay? But we do have sensitivities that we have to take into account when we're dealing with future applications if we apply the law inconsistently.
Absolutely.
So when I say precedent, it's not like legal precedent that we would apply in a case law context.
Of course.
But it is precedent in terms of consistency in the way that we approach similar applications.
Understand.
2 ADA applications are going to come before this board
course.
again, and other applicants are going to look to previous rulings to ensure that we're applying the law consistently with their application as we did with yours. And
we've sat with the building inspector going through what 280A means and what the process is, and the planner is now, very much aware of it. And this was discussed with town staff. So this wasn't the applicant building a resident, so to the extent, even though hypothetical, someone goes onto land, builds a residence without permission, without permits, and says, hey, you know what, I didn't know, and comes to you. That's not the case here. They had a building permit to do the work. They have a tax parcel ID. They've been paying tax for the lot. They had an existing lot. They did a land swap with the state. As soon as they were advised to go through the subdivision process, they met with town planners and staff and went through that process and were told to proceed with all of these aspects.
And when were you,
Yep.
so.
So it won't set precedents, I think, where I'm going with
I
this.
understand you're
It's
trying to
unique.
make the
Yeah.
distinction, but when were you told formally when were you first advised that this was an issue?
So,
The need
November?
for- in November.
November.
Right.
Yep. Yeah, I think the applicant formally submitted the subdivision
That was the
plan.
first time you became aware. It was not beforehand that this.
No,
was
the
brought
applicant
up as a
discussed-
particular issue, or was a concern of anybody in the town that this lack of a variance.
What I understand,
possible
Acting
issue.
Chairman, is that that counsel for the town indicated the relief wasn't necessary, but further review by the building inspector through the process identified this as a need.
Yes, so, and I want to stick to the subject because the determination has been made. We're here, we have this in front of us now.
Yes.
I understand that there's a history that needs to be considered, but I don't know that we need to go too much down that rabbit hole because we have an application for variance with specific elements that we must consider for that.
Right.
With that being said, I'd ask you to hold off now
Understood.
and take any public comments, and I'll give you a chance to respond to things.
Thanks.
That being said, is there anybody that wishes to speak on this application in favor of the application? Is there anybody here that wishes to speak against this application? Seeing that there are no requests for public comment either way, the chairman recommends that we hold this matter over to the end of the meeting for a business session. Is there consent to this?
I'll second that, Mr.
Second,
Chairman.
yeah. Third, aye.
Consent? Or any opposition? No opposition, we can move on. We don't have to.
Thank you. And just for the record, just because of the nature of the application, and it is a planning board pending application as well, we would ask that the board, if it does decide to proceed to a decision this evening, that it do hold the meeting over until next month, so that we can send an informational. It's not a referral, but an informational reference to the county, because it does abut a state property and does deal with lot frontage on a road. So we'd ask that the board hold open the public hearing because it needs to be referred to county within 10 days before a hearing. So we would just ask the board consider that.
But by that comment, then we cannot make a decision tonight.
Absolutely. So I'm asking you not to make a decision this evening, but if the board would see fit after its business discussion to potentially consider setting it for resolution for next month.
I'm not sure that we are going to be in a position to make a decision.
Understood.
But what you're saying is you would prefer that we
Not.
don't.
Right.
We will discuss it later.
Understood.
We will discuss it.
Thank you.
Just one more point,
That would
Council, just
that would
since I have you up here, and one of the things about the timing that I'm unclear about, in terms of the land swap,
No, no.
what year was that effectuated?
I think 2016. It's in our submission. I can pull it for you.
And when was the, I'm assuming that that's a ballpark that's probably pretty close to whatever it is. It's not so significant what year, but what is significant is whether or not the conversations you alluded to with the building department Did those conversations take place after the land swap or before?
So the conversations with the building department with respect to the frontage,
Well, you had indicated that you had received representations from the town attorney, members of the building department,
I'll let you
and
speak
that
to it 'cause you guys
those
had that.
conversations had led you to believe that this home was going to be viable without the need for a variance from 288. When did those conversations happen, and when
I'll
did
let Til
the
Globig
land
speak
swap-
to those specific questions. We weren't involved in the initial deliberations. We were brought into the application when the subdivision was first presented.
Name and association,
I'm
please.
Til Globig. I'm the architect for the project.
Do you swear or affirm to tell the truth, the whole truth, and make all statements to
I
the
do.
most accurate nature that you can?
I do.
Thank you.
January of 2019.
Is the year of the swap?
No, is when we met with the building department, the planner and the building department, and we discussed this issue in particular.
Okay.
It was described that there would be these two easements which would give us frontage onto Bedford Road. And it was essentially stated that, yes, there are other properties in this vicinity that have that same condition, and therefore this would be accepted.
Okay, and what year was the land swap done?
2016?
We're thinking 2016.
2016.
Everything's recorded in 2018, but the land swap discussions are 2016.
Okay, so the land swap basically preceded a belief that this was going to be a viable developable lot without the need for a 280A variance.
Correct.
So that was a significant risk that was taken without any
Just to clarify, the
misleading
existing,
approval
the
or
existing
misleading
lot,
guidance,
Sure.
misleading guidance perhaps provided by representatives of the town. So in effect, when you came to that meeting in 2019, you already had a landlocked lot that you might have come to realize was going to be an issue.
so the Pearsons had a lot fronting on a public road. They had the sufficient acreage, they could have built a residence.
That's why a flag lot here would make this a non-issue.
Well, but we asked that question, that specific question. We came before the town and we said, we have this lot that's landlocked. Can we build on this? And the answer essentially was yes.
But you bought the land or swapped the land without that expectation.
I can't speak to that specifically, obviously, but.
But just the
I-
timing of it, in effect,
Keeping
the
in mind, this
swap
was-
was done prior to
Sure.
any indication from
Yes.
town officials that this might be a developable lot.
I mean, I can't, I won't speak to
I'm
that,
just
but
doing,
understood. But again, this is a very, you brought up precedent, so just to sort of weigh in on that again, this applicant also received a building permit to build the residence. 280A, if not permissive, wouldn't have
we're not
enabled
gonna-
them to do that.
It is not my intention in any way to make anybody tear down a house that's fully completed, especially under the circumstances here. So I don't want that to be a takeaway from what I'm driving at. But what I'm driving at is, again, alternatives that exist that are available, although they may not be as attractive as the proposal you bring before the board today. We can't ignore the fact that there is an alternative that's available and it hasn't been explored.
If I could speak to that for a moment.
Sure.
There are steep slopes, so we were before the planning board to get a steep slopes permit. And the steep slopes are essentially in this area, so making it very difficult to get. If you were to have a flag lot, if you were to come in off of Bedford Road here, for example, this is very steep in here. This is very steep in here, so that would make it actually very difficult to get up to the house from that point, from that part of the lot. And that was all discussed with the planning board when we got our steep slopes permit.
After the land was swapped for and after it was owned with no, again, assurance that it was going to be a developable lot. Point being is that, in effect, that burden was taken on by the homeowners on their own accord.
I think it's a very unique situation. The applicants, again,
It is, I'm not
could have
denying that.
absolutely built a house on a public road and have swapped for preserving, for the benefit of the public and all
Again,
of us,
for
state of New York,
reasons that are their own.
and also for the benefit of the state of New York and for those of us here that have rights to utilize state property and
We
parkland.
understand, and we already talked about moving on, and we spent, it's been a long time. We
Thank
can't
you.
have the town the town zoning board is under no assuming any error or guidance
course.
was made that turned out to be incorrect after further explanation, or not, and I'm not opining on it one way or the other, the zoning board is not under any obligation to continue an error if an error did in fact occur.
Sure.
We have to look at the application for what it's worth, the merits before us under the relevant code. And
Exactly.
we have a lot of information to do that.
Great.
The acting chairman and myself suggest that we move on to the next application, we discuss this in business session, and if we need to come back and continue a public hearing, we can do so. But I would like to move on.
Can we let her make a point while we're...
I just wanted to,
Please.
to speak to one issue, and that was that the reason that the state came to us and said, we want to swap these two pieces of property is because the field where you could put a driveway was part of the nature of the park in that area, and they didn't want there to be a house there. And so we said, fine, we would be happy to swap those two pieces of property. Naively, not understanding what went into that, but if we'd said, well, sure, but we just need to make a driveway up there, then they wouldn't have, I mean, we can ask them, but I think they would have said absolutely not. So anyway, it's
So
just.
back it's in 2016, whatever that date was, the state came to you.
Oh, yeah, absolutely.
You didn't come to them.
No,
I wanted to build
no.
a house up here in
No,
the
no,
future."
no, not at all. No,
Okay.
they came to us and they said, we would like to swap these two pieces of property. So we said we would be happy to, entertain that.
But when you made that agreement, or when you indicated you would be happy to do that, were you planning to build on that now landlocked lot that you were swapping
Yes,
for?
absolutely, absolutely.
Thank you. All right, we will discuss more in business session if we need to have the applicant come back up at a later date or later on, we will do so. We're moving on to the next case, which is case number Z-24-1, Frank Gregory, owner of premises located at 186 Evelyn Avenue, Thornwood, New York. Is Mr. Gregory here? Yeah. Come on up, sir. I'm going to continue to read it to the record. The application is for section 106.19, block 2, lot 29, for a proposed installation of a 14 kilowatt generator on a legal substantive parcel in the R10 zone. The following variance requested is a side yard setback variance. What is required is 10 feet. The current existing is 8 feet. The applicant is proposing a 4.4 foot setback, thus a variance of 5.6 feet. Before you begin, Mr. Gregory, I would just make a note for the record that during business session, there is no public comment. It is discussion amongst the board only. If the board feels the need to inquire with an applicant during the business session, they can do so at our own discretion, but it is not a back and forth like the public hearing. Thank you, sir. Mr. Gregory, do you swear to tell the truth, the whole truth, and make all statements with the most accuracy that you are able to do so tonight?
Yes, I do.
Thank you. Can you please tell us about your request?
Okay, my request is rather simple, I think. It's just for a full house 14 kilowatt generator in case we lose power. It's an automatic generator so that if I'm away or if something happens, I still have heat and hot water and my pipes won't freeze. As I told some of the board members who came on site, myself and my two neighbors who are also applying for generators, we're all getting up there, we're all seniors now, and we're all dealing with certain health issues, so we can't be without heat and hot water for any length of time. So we're looking at this, taking the opportunity now that the gas moratorium has been lifted, that we're all going to get generators, at least 3 of us anyway.
Did you explore any alternatives as to placement of the generator?
I did with Mr. Nicoletti, the town engineer. We looked at the site plan, and he said this was the best, simplest, most straightforward position to put the generator. He said any other place would require running gas and electric lines all around the house, and we don't want to do that. In addition, where the generator is located, where proposed location is on the side of my garage. On the other side, inside, is where the electric panel is. So it's a straight, right through the wall, hook up to the transfer switch.
Questions from the board?
No, Acting Chairman.
And that's the left side of your house?
If
right?
you're looking at the house,
Looking at the house.
yeah, it's my left, yeah.
Right, you had showed us. And nothing currently exists that's obstructing its placement?
I'm sorry.
Nothing currently exists that's obstructing its proposed placement,
No,
right?
no.
Mr. LaFasis?
Just with regard to the location of your home, with respect to the adjacent home,
Yeah.
what's the distance between the two?
I didn't measure it, but I'd say about 20 feet between me and Allison. She's also applying for a generator too, by the way. Yeah.
Is she putting her generator in the same on the same side of her house that would put it abutting your generator?
Honestly, I don't know the answer to that. I know she met with the plumber just yesterday, and she took off this morning for vacation, so I didn't have a chance to really talk to her.
Okay. Well, I mean, we did, again, do a site visit. We did see that the only neighbor who would appear to be affected would be
Allison, yeah,
your adjacent
yeah,
neighbor.
yeah.
It does sound as though you've spoken with her and...
Oh, yeah, no, I've been there 25 years. We've been really close neighbors, and even the neighbor on the other side of her, 2 houses away, Judy Germano, she's applying for a generator as well. We've all been waiting for this, and we're all good neighbors. We all help each other out, and I want to continue to be a good neighbor. And the other thing is, I want to stay there. I'm not looking to move. I don't want to go to Florida like everyone else or wherever they're going.
for you.
And I want to leave my house to my daughter when I go. So,
All right, thank you. That's all.
all right, thank you.
No, sorry,
Yeah.
so your neighbor, the lady you just mentioned, I believe Allison?
Allison
If
Propp, yes.
If you're looking at your house, she's immediately to your left?
If you're looking at my house, yes, there's only one house next to me, and that's on the left side.
Okay, so that house, and she's, as far as you know, in support of this application?
Yeah, no,
Okay.
yeah.
Do you know, is she here tonight?
No, she took off this morning for a vacation.
Okay.
So,
All right, but you... Okay, very good. All right, I'll ask you to wait, see if there's any public comment, and I'll give you a chance to
sure.
respond. At the
All
end.
right, and I want to thank the board, and especially Mr. Clario for helping me through the process, Mr. Briganti for the site visit and his advice too. So thank you.
Thank you, sir.
Thank you.
Is there anybody in the audience that would like to speak in favor of Mr. Gregory's application? Seeing none, is there anybody in the audience that would like to speak against Mr. Gregory's application? Yes, sir, please come up. Sir, as you approach, please state your name and address and your association to the case.
My name is Steve Serace. I live at 4 Lilac Place in Thornwood, and I own the Kingsview subdivision directly behind those 3 neighbors.
Mr. Serace, do you swear to tell the truth, the whole truth, and make all statements to the most accuracy that you can?
I do.
Thank you.
So basically, we have a non-conforming lot and a non-conforming side yard. And I think that although the variance is a very small footage, that the percentage of that variance is very large. And I don't think the board should grant that variance because of the size of the percentage of the variance, whether the neighbor agrees with it or not. I just think it's too big of a variance on a non-conforming lot.
Understood.
You said you own the property behind?
Yes.
And what do you do with that property? Do you live there? Do you have
No.
tenants there?
I'm developing it.
You develop it?
Yeah.
Right, what issue do you see?
I'm
What
sorry.
issue do you see with the placement of the generator?
I just think that there's another place that he could put it that he doesn't need to try to get such a large variance for.
Other questions for Mr. Serace?
And Mr. Gregory did mention that the moratorium has been lifted, but there is no gas on that road.
Understood.
So to put a generator in now would have to be propane. There would also be tanks there.
I'm sure he would have to work that out with the building department. But, any other questions for Mr. Serace? Seeing none, thank you, sir.
Okay, thank you.
Thank you.
Last call for anybody to speak on application Z24-1, Mr. Gregory's application for a generator. Seeing none, the acting chairman will inquire with the board if they wish to vote on this now or hold this over for a business session.
I make a motion, we hold it for business section based on the objections.
Any objection to Mr. Dorr's motion? Seeing no objection, we can move on consent to hold Mr. Greger's application over to the business session and move on to the final application for tonight, application Z24-3. This is the Katova application as the owner of the premises located at 11 Point Place in Chappaqua, New York, section 99.10, block 3, lot 47. The application is for the proposed installation of a 15-foot by 34-foot in-ground pool on a legal parcel in the R40 zone. The variance requested is a rear yard setback. What is required is that any structures or pools be 50 feet from the rear yard. Existing is not applicable as there is nothing there at the time. Applicant is proposing to put the pool 25 feet from the rear yard setback, thus requesting a 50% variance of 25 feet. Does that sound correct, sir?
Yes, good evening, board members and acting chairman. My name is Nicholas Shariah with Hudson Engineering. I'm here representing the applicant and homeowner Katerina Katova, who's here tonight.
Okay. And sir, do you swear to tell the truth, the whole truth, and make all statements with the most accuracy that you're able to?
Yes, I do.
Thank you, sir. Please tell us about the application.
Absolutely. As you previously stated, this application is for a variance for a swimming pool in the rear yard setback. The required setback is 50 feet, and we're requesting a 50% variance. This application has already been approved for steep slope disturbance through the planning board, and currently has building permit for construction. During the course of construction, we discovered that the original location of the pool was too close to this area shown on our map here. The location would not have been ideal for the pool in that location. We came to that realization afterwards. We had some inaccurate information on the topographical survey. So, as discovered by the contractor in the field and myself, we discovered that the best location for the pool was to set it back 25 feet. However, that does encroach into the rear yard setback. This property is kind of unique in the way it's set up. Most of the rear yard is steep slopes, as you can see. There is a chunk of rock that was basically cut out of the rear yard to make this area in the immediate backyard flat. Not a lot of area to be used for recreational activities for a family of, I believe Mrs. Katova has 2 kids, and they definitely like the use of their backyard. So we figured that the only place to put this pool would be up in this area here. Again, with the way that when the house was built, the way the excavating was done, there's basically a 10-foot difference between the top of the area back here and the base behind the house here. Again, just for the practical use of that lot, this area there's no real practical use to it. So again, we had to locate the pool on top of this area here. Again, it's not, we don't really have too many options for the placement of the pool at this point. We tried in our initial application to the planning board, we tried to locate it within the setback, but again, due to some inaccurate topographic information, that location is not very viable. So we're asking the board tonight to consider a proposal for that 25-foot setback in the rear yard. In addition, the property in the back of Mrs. Katova's lot, it's forested. There's no other houses or anything that would be obscured by setting the pool back another 25 feet. The only property, or should I say that might be affected, well, not really affected, but there's a 50-foot wide easement for Con Edison towards the rear of the property. But again, there's no homes or anyone that might be affected, or it would not be aesthetically objectionable for the pool to be back there. So there's really not really too many objections I can say to putting the pool back here, other than the fact that we will be in the setback.
So, a few initial questions. So, because of what you mentioned, the power lines and the Con Ed easement, do you know if the rear property is potentially buildable or protected by any law or statute which would prevent anybody from building back there, or is it just effectively non-buildable because of the Con Ed easement?
Well, I would say for the most part it's non-buildable. I mean, there's abundance of steep slopes in the rear yard, and that 50-foot easement here kind of cuts this area pretty much by 25%. So I don't think we would meet zoning setbacks or zoning requirements for a lot in that R40 zone. I'm not sure who owns the property back there, but again, that 50-foot easement kind of runs through most properties on this subdivision. This is the Zapati subdivision that was done a few years ago.
Yeah, we're familiar with this.
Zapatico, I think.
This whole area. The board is intimately familiar.
Yeah.
The neighbors to the immediate right and left, have they expressed, are you aware if they've expressed any support?
So I haven't really been able to speak to that. They are obviously noticed about tonight's meeting. There was no negative feedback to Ms. Katova, who's here tonight in the audience, but I don't think she's had any discussions about whether this would be, something that they would object to.
Questions from the board?
Now, currently, the fiberglass pool is on property.
That is correct. Like I said, the construction is well underway until we discovered that we were so close to the edge with this pool that, the safety would, it would not be a safe situation for anyone that would use that pool. So, again, we had to set it back. We tried to set it back as far as we can to maintain that safety.
You're also setting it back and you're elevating it.
No, so again, we're not, we're doing a minor amount of grading just because this area is relatively flat as it is. We're doing a minor regrading around the pool area just to make that area completely flat, but we're not raising the grade.
You're telling me there's no rock that you have to go up like a nanny goat and walk around to get to where?
So we do have a set of stairs from the back that leads up to this area, but again, as it is relatively flat area.
Up on the top.
On the top, yes.
So you can't bring it any further in closer to the house without bringing a jackhammer in there and ripping that rock out.
Correct.
So what I'm saying is you're not only from where the pool is currently sitting,
Yes.
you're elevatedly putting it back and you're putting it up.
Essentially, yes.
Because when we stood up there, because it was all marked out, if the markings that we saw on Saturday, I was looking into the second floor of this house. It's not just a slope coming down and it's flat over here. You're on top of a rock that you have to do some excavation to set this down into to fit into what you're saying.
You are correct, yes.
So where it's sitting now, it couldn't be dug and put in place because it's too close to side and building?
So, when initially it was set closer to this area right here, but the information that we had on the topo map.
In other words, whoever looked at this initially did not see that rock.
Correct.
Mountain sitting there.
Yeah.
Okay.
Well, we were aware that there was a drop off, a 10-foot drop off, but.
Well, if I'm going by the topo on here, it's a little more than 10 feet, but that's okay.
So could I just ask, when we went and did our site visit, obviously, as Mr. Dorr said, the pool is currently situated on the property. I don't see if, where we have this, this drawing with a double S with a circle around it, is that about the location where the pool's sitting right now, or is it even further up?
So I'm not sure exactly where on the site the pool is currently sitting.
You see that
This is the soil stockpile area.
So it's a little bit closer to the house than that right now, where it's
Right.
resting incident to installation.
Correct.
Okay. It appeared as though that area was an option, a viable option for installation of the pool. And I think what you had said was that that area is ledge or rock, and it's very difficult to, and expensive to put the pool there because of that, the nature of the soil there. So how is that different from now where you're looking to place the pool, which looked to us to be, in effect, a solid rock ledge hilltop in the backyard?
So essentially, fitting this pool in this area, you would be, once you exit your house, you'd be basically into the pool. You would we're required to chop this back some more to actually fit this pool here. If you place this exact pool as it is in this area, you would essentially walk out of your house 2 steps into a pool.
Well, we have setback requirements for pools from houses, but did you actually, see, I guess what I'm getting at is whether or not you explored alternatives and whether or not you actually know that the 50% variance that you're currently seeking might have been a lesser variance if you had placed the pool off of the top of the hill, closer to the house, but required a far less than 50% variance, although still perhaps a variance would have been needed. It wouldn't have been as significant as the one that you're seeking now, and then it might not have created the issues that we observed, which is, in effect, you're putting this giant stage on top of the neighborhood so that
I
any
understand.
noise that comes from this pool is going to be heard for 500 feet around. It's going to have a significant noise impact on all the neighbors in the area, which we recognized. I don't know if perhaps it was recognized by the homeowner or by the pool installation company or even by the neighbors, but it's because of the, again, topography, the fact that this pool is being placed on top of a hilltop, which is significantly above the level of all the homes in the cul-de-sac.
Correct.
It's going to be like a giant stage, and if they put lights around it, it's.
No, I
You
understand.
ever see Close Encounters of the Third Kind? Okay,
Absolutely,
it's going to
yeah.
look like a showpiece of lack of privacy and significant noise.
So-
and I'm trying to explore an option that, even if it required some variance, maybe smaller in percentage, and put the pool closer to the house, it doesn't appear as though there's any sewer lines that would obstruct that. So I'm trying to get a sense of whether or not that was explored.
So the other consideration for this is the stormwater treatment for the pool that, we have to consider.
Well,
Essentially, since there is nothing but ledge here, there's no way we can do infiltration or anything to that nature. So even if we try to do some kind of attenuation gallery or something like that, it would require connection through the street here with an overflow to this catch basin, and there is not enough setback area to do any kind of stormwater, which is why essentially this is the only area available to us, notwithstanding the well on the property, which we also require setback from. So again, we took everything into consideration when trying to figure out where exactly this pool could land. It's not ideal, but again, this is something that we brought to the board, the planning board. They didn't really have too many concerns with it. I attended that meeting also, and there were no neighbors at that public hearing as well. So, Mrs. Kotova's neighbors must love her, and maybe they'll come over for a pool party or two. I don't know, but again, we've kind of looked everywhere on this lot to make sure that this is the right area for this pool. And unfortunately, like I said before, topographically, we had some inconsistencies, but we're trying to right that wrong and make it as safe and as functional as possible.
thank you.
Any additional questions
No.
for Mr. Schreier, correct?
Schreier.
All right, I ask you to hold on a moment, let's see if there's any public comments. Is there anybody here that would like to speak on the matter of zoning board case Z24-3 Katova regarding the pool? There does not seem to be any member of the public that needs to speak either way, so thank you, sir, for your presentation. I'd inquire now with the members of the zoning board if you would like to vote on this case at this time or move this over to business session.
I think we should move it to business session.
Any objections? Noting no objection, we could handle this matter in business session. Is there any desire to go?
How about we go in reverse
Yeah,
order?
I was going to say, we should do that. All right, so let's talk about, so the purposes of the business session, again, it is an open forum in the sense that the conversations are public. However, there's no public comments. If we need to inquire with a member of the community or applicant, we will do so. So let's go. The pool, what do you guys think? Thoughts? Okay, please go.
I mean, obviously, we love the site. Obviously, there's another sort of kind of application that we've had in the past where it's obvious somewhere along the line somebody did their homework prior to a pool being purchased and put in place from that standpoint. I mean, looking at the plans, at this point, it's probably, even though it is a 50% variance, I'm not sure it impacts anybody other than the sound that George brought up issue and being up that high, that maybe they can put plants or vegetation around from that standpoint that can buffer that a little bit. I don't think they have any other option. It's not like you can go on the opposite side, because looking at the plans, the elevation and topography doesn't support that side either, and that's where their well is.
Ton of other issues
You
as well.
can't put the well and stuff on that side. So I think it's making the best of somebody else's, and I don't believe, unfortunately, it falls on the homeowner. I think the entities that did the planning or poor planning ahead of time is what's impacting this more so.
But the only option really would have been to, they really couldn't put a pool anywhere else, so they would have had to just buy a smaller pool, but still put it in the same spot.
Well, I mean, they could have come down in the front, but like to his point, he even mentioned, I mean, you're walking out the house, and we've had this in the past, and we've denied it, where it's right by it.
They don't want that.
I mean, this is the complete opposite that we've had. In the past, we've had where we're trying to prevent people from diving into the pool. This one's people diving out of the pool and falling down a cliff, which is kind of interesting.
Yeah, so that had that on my mind too, that we should have some types of conditions, not only to what you said about buffering, but also gating or fencing for the.
Well, I mean, the plan, it does show fencing.
Well, I think we should condition it then.
I have no problem with that, or something that prevents the sliding down and rock climbing to go swimming. We're not in Acapulco.
George, what do you think, George?
I mean, I'm concerned about the impact it's going to have on the neighbors. Certainly, I think sound and light are going to be negative impacts, but we can ameliorate those with some plantings, fencing. You know, again, they didn't have a lot of options. I did think that it was worth exploring whether or not they could have put it below the hilltop. I think the applicant's representative did make the point that they did explore that, and because of the need for the Coltex system, they actually didn't have any other location than to put the drainage. So if the pool wasn't up on the hilltop and was below, then they wouldn't have a place to put the Coltex. So in effect, this was the only available option for them. And with buffering, I would support it.
Scott?
I agree with that. I mean, at this point, we're accommodating a pool that looks a little too large for the area. And that's unfortunate, because like what Herb said, it looks like it was just poorly planned, perhaps.
And to your point, Scott, it's kind of tough to visualize because most of the pool that you would normally, that you would see would be on the ground. And right now, we're seeing a shell that's sitting there that makes it look way bigger.
Gigantic.
Than what it is from where it's being placed. Because you gotta look at the size of it. So your perception of looking at that thing, plus it was in a weird spot where it's sitting there. So obviously somebody somebody had a crane there, lifted it up, because there's no way they put that on the side and rolled it in, you know, from that standpoint. So, you know, so a lot has already gone into this,
fenced too,
you know, and I think to your point, Nick, if we put some both screening plants and safety factors into that condition, I'd be in favor of some.
I think that could really limit any noise pollution, if you will.
Would somebody like to fashion a motion?
Okay.
Scott?
It was just, Mr. Chairman, I motion that we approve this application subject to certain conditions of siding and perhaps shrubbery.
The conditions, we said that there's fencing on the plan,
Fencing
right?
on, close to the, I mean, there's fence on the plan.
Right, that's what I mean by
but
siding.
along the
Fencing.
cliff section, the steep.
Fencing along the cliff, right, so to protect the 10, well, I don't know, what is that? What do you think, Herb? You said 10 and a half feet?
Oh, yeah, I mean, the drop off,
Yeah.
without getting into.
Between the pool and the house.
Between the
The
pool and the
large
house.
drop off.
And any more particulars on the types of buffering with the noise
No.
buffering?
Well, you're going to want fast-growing arborvitae, perhaps. I know it's a common evergreen, something that would provide a degree of noise and light minimization.
Do we want the three-sided? Like
Yeah, that would be necessary to alleviate the impact on, or ameliorate the impact on the neighbors.
so I have a motion from Mr. Travella to.
I'll
Sorry?
second.
All in favor?
Aye.
Scott?
Aye.
Sorry. Herb seconded, chairman votes aye. Matter passes 4-0. Thank you, sir. We'll get that vote smoother next time, sir. All right, moving backwards in the agenda, 24-2, Mr. Gregory's application for a generator.
-1,
Sorry?
-1.
Sorry, yes, 24-1.
You were going backwards, but.
I was, and that was the adjourned application. Thank you, Mr. Dorr. It's always a team effort. So 24-1, any comments on the generator case?
I mean, I have a question of the rationale of the negative comment, you know, the comment against it. I didn't see, I mean, I understand the percentage from a variance standpoint. If you look at the property, even the building department mentioned to them, if we tried to put that on the other side of the house, you're tracking it. I do want to ask Joe, excuse me, there's no gas main coming up?
I'm not sure if that's accurate because I did a site inspection on 2 houses down, as you mentioned, you're having a generator installed. I did see a gas meter. So 2 houses down, there's a meter and they are going to natural gas.
Because he didn't mention, the applicant
I'm
didn't
not sure
mention
if it's gas.
propane, because we did ask on the site visit, are you going propane? And he said, no gas.
Yeah, I thought,
And we did look.
didn't he
on
say
the
something about
streets.
it just being,
Well, the moratorium was lifted, which means you can tap in and you can start using gas again, unless the state comes
2
back.
houses
and
down,
limits
there's
it.
gas.
All right, so then there is gas on the street that if it might be a joint main coming to both houses.
But for informational purposes, for our edification, we're approving a generator that's on the plans to be a gas generator. But let's just say it was a propane generator. That would change the application because we would have to account for where the tanks would be. Correct, Mr. Brigham?
The tanks don't meet, the tanks go by the fire code setbacks. They don't go by the local zone code.
Right,
So I
I
believe
mean, they're
depending
fire,
on the
so.
tank.
so our approval of this application as submitted would not allow for a propane use. It would only allow for a natural gas use.
Because it could also be an in-ground propane.
But this approval doesn't allow for an alternative fuel source. It only allows for natural gas, is that right?
Or no, I believe that these.
No, it's a gas generator.
Well, we're approving where the physical
The generator can go.
would be, but
Correct.
if it needs a supply source, like as
Right, what does
propane-
the applicant do then?
Right, I think he would have to factor it into, like Mr. Briganti's saying, whatever the fire codes are for that.
But he wouldn't need to come before the zoning board for that, and he would be required to obtain the approval for the location of those propane tanks if he chose to go that route. But all we're gonna legalize is the location of the generator itself, which doesn't necessarily allow him to have an operating generator. If he goes with propane, he would need to take another step and get an approval for his tank location.
You're not,
Okay.
he's not legalizing this generator, you said legalized.
Authorizing.
Okay.
Authorizing it. And so, and I think it's an important question to ask, because as, you know,
I just want the applicant to have guidance on that, that in effect, this
I mean, because theoretically, he could switch the
is
diesel
subject to
oil.
other
Right.
requirements that he needs to be aware of.
No, but it's not, the point being, again, as George stated, we're approving a generator, whether it's
Location.
the location, but if he does decide or gets frustrated with Con Ed or the idea of trying to get gas, which could take a while, and he turns around and says, I have approval for a generator, I'm tired of waiting for the gas company to hook me up, I want to make it a propane generator, he could still put in that generator, but the accounting for where the propane tanks go would have to go through a different process. And they would either be approved or not approved based upon compliance with that separate process. Okay. Any other comments or questions on this?
No, Mr. Chairman, I'll make an application at this time to approve as submitted application Z-24-1.
I'll second.
Aye.
All in favor? Mr. Travella?
Aye.
Chairman votes aye. Noting the motion and the second, Mr. Travella's vote, the matter passes 4-0. Okay, moving on to... Thank you. Moving on to the first application that we heard tonight, zoning board application Z23-59. Form is open for discussion. There is a lot to discuss here. First and foremost, before we get into the merits of the case, the chairman or the acting chairman would like to. I would like to just try and clarify the board's take on the applicant's position at the end when he was talking about holding this over, notifying the county. And Mr. Clare, did you have some clarification on that, or did you?
Yeah, so that contacting the county only goes for when they go to the planning board, not for zoning. So when they go back to the planning board, then the county would be notified, so it has nothing to do with our board. And Carolyn did clarify that this afternoon.
So I'm not clarifying that.
Yeah.
So
So
we're holding our vote for what reason?
You don't have to. They would contact county when they go back to planning board, not from our board.
So
So he
I'm
thought,
still clear as mud.
he thought that he would have to hold this over so that they could contact the county 10 days prior so that they're aware of the application, but they don't need to. Carolyn clarified it this afternoon that it only would have to go when it goes back to the planning board, not this board. So they would get notification 10 days prior to the planning board.
So, Mr. Chairman, in light of that, do you want to allow the applicant to amend his request that we not move to a vote on his application? Or do you wish to accede to the request and not make a determination on the application this evening?
I would think it would be appropriate that we hear from the applicant on this narrow issue. If you have a comment on that.
Yeah, for the benefit of the board, I do have a copy of the form that would be required. So just to clarify, general municipal law in Westchester County, the county has, as you may be familiar, they've used home rule to change what the requirements are for general municipal law. There's either a referral requirement for very specific applications, think of broader, much bigger projects where the county will say this impacts the county bus system or this county park system. This application as a variance for a setback, for a frontage, specifically for frontage, would require an informational notification. So not a referral, but an informational letter that just gets sent to the county, and they literally just go, thank you, and they don't make any comments. That's just, it's a listed prerequisite for this application. So we're just merely asking the board to hold over. Again, it's effectively detrimental to the applicant to have to wait, but we want to make sure that procedurally we don't have any hang-ups.
So on that point, regardless of how we interpret this form, as I mentioned at the beginning of the meeting, we only have 4 members.
Right.
We don't have a full board. You have a right to request that we adjourn the hearing until the next meeting, until we ostensibly have a full board.
Understood.
So would that be something you would like us to do?
Actually, Chairman, yes, we'd ask that you adjourn this to the next hearing in light of the 4 members present this evening.
Thank you.
Thank you.
Yes, please.
Well, then, based on that, I'll make the motion that we adjourn this to the following month.
And
I'll second.
I would ask that that Mr. Doerr's motion also include a notation that the public hearing will remain open until the next meeting as
The
well.
public vote hearing will remain open during that time period.
I'll second, Mr. Chairman.
Mr. Travello? Aye. Chairman votes aye. Matter is adjourned to the next meeting.
I make a motion, Mr. Acting Chairman, that we adjourn the meeting.
Any objection?
No.
No objection. We are closed on consent. Thank you very much, everybody.
So any time.
Put us off.